I'm going to start off, my talk is about philosophical beliefs as a protected characteristic. And I tend to find it's one of the protected characteristics we forget about, actually. You probably see fewer cases relating to protected characteristics by way of philosophical belief than most others. How much does it really take to prove that one has a philosophical belief? Now, why is it important that we recognize this? It's important because it's plastered all over the news at the moment, and there are some huge cases which have made their way through employment tribunals and the Employment Appeal Tribunal. The gender-critical debate is but one fertile ground for cases of this nature in the employment sphere, and we look no further than the Forstater litigation and the more recent tribunal litigation in the case of Bailey. Now, what is a philosophical belief by way of a protected characteristic? I'm not going to bore you with the legislative provisions. We all know that a philosophical belief can be a protected characteristic, Section 10 of the Equality Act 2010. But the starting point, and if you look to your handout at paragraph 6, it was set out very clearly in the case of Gray and Mulberry Code Design Limited. As may sound like common sense to us all, but I'm absolutely certain doesn't find its way into every set of pleadings in the Employment Tribunal, the first and most important question to answer is, what is the belief that the person says is protected? And we see there, I've set out the dicta in that case, paragraph 6 of the Court of Appeal, which says precision in pleading is not equally important in every case heard by employment tribunals. Well, that may well be another statement if ever I've heard one, because you will all know how pleadings can turn out in the Employment Tribunal. And there are two things I would say from a procedural perspective. One, if you're a claimant, get it clear and get it right in your pleadings. And two, if you're a respondent, if it's not clear, ask what it is. Because it might well be that once it's written in black and white on the paper, this is an area ripe for a preliminary hearing. You may have a knockout blow, for example, if it's not a philosophical belief. So what is a philosophical belief? We should all, and we will probably all be familiar, but it is absolutely imperative, if we're not, that we read the case of Granger PLC and Nicholson. And I've set out in the handout, the paragraph 8, what have become lovingly known as the 5 Granger criteria. And those criteria are set out therein, and it's worth me just repeating them. First of all, the belief must be genuinely held. Second of all, it must be a belief and not an opinion or viewpoint based on the present state of information available. I think that one's probably easier said out loud than it is to apply in practice. Thirdly, it must be a belief as to a weighty and substantial aspect of human life and behaviour. Fourthly, it must attain a certain level of cogency, seriousness, cohesion, and importance. And 5, it must be worthy of respect in a democratic society, be not incompatible with human dignity, and not conflict with the fundamental rights of others. Now, I just want to ask us all to pause there and consider those 5 criteria. Because to my mind, when one reads those criteria on paper, they are a set of stringent, very difficult to surpass criteria. You may disagree with me, but certainly when I read them on the page, it makes it sound very difficult to prove what amounts to a philosophical belief. I want to ask the question, is it that difficult to prove what amounts to a philosophical belief? And you'll see in the handout, I've tried to go through some of the criteria, and if we look at paragraph 6, in relation to the first criteria, which relates to whether or not the belief must be genuinely held, and I've cited there the case of R.Williamson against the Secretary of State for Education and Employment. And that case makes very clear that the inquiry of the tribunal is simply to ensure good faith. Now, to my mind, that isn't a very difficult hurdle for a claimant to surpass. For a respondent to defeat the test at this stage, they would ultimately having to show the claimant is acting in bad faith. We all know how difficult a test that is as practitioners if we've ever practiced in the field of whistleblowing or victimization. It is not an easy feat, and tribunals, to my mind, would be reluctant to find anything like bad faith. Second of all, the criteria which requires that it be a belief rather than an opinion based on the present state of information. Now, I've cited there a case of Makareth at 7C, and this is where the learned President Eadie acknowledged the difficulties that can arise in seeking to define in general terms, the precise distinction between a philosophical belief. Well, President Ely wasn't wrong there, because even when one looks at the case law, I would suggest it is a struggle to discern between what amounts to a belief rather than an opinion based upon a present state of information. But you'll see from the case of McClintock, which I've got in your handouts at 7a, which says there is a distinction between a belief qualifying for protection and an opinion based on some real or perceived logic or based on information or lack of information available. One of the reasons in that case the claim failed was because the claimant's objections were not based on a question of principle, but rather on the ground that there was insufficient scientific evidence to show that same-sex adoptions were in the interest of the child. Now, I think, again, this is a criteria where one may be spinning on a sixpence, because where does the line get drawn between having an opinion, which inevitably will be impacted by the modern state of information? COVID and the pandemic is a ripe area for that kind of challenge, but it is a difficult one for us as respondents or for us as employees to determine or give any clear advice as to what amounts to what. I've taken you through, and if you look at paragraph 8 of the handout, criteria 4, I've missed criteria 3, but criteria 4 must attain a certain level of cogency, seriousness, cohesion, and importance. What is said there is that it needs to be worthy of respect in a civilized society. Now, I would question, perhaps rhetorically, well, in the pluralistic society in which we live, what belief isn't worthy of respect in a democratic society? There will, of course, be some at the extreme ends of the spectrum, but isn't it difficult to challenge a claimant who, by this stage of the test, is being found to be acting in good faith, limb number 1, to then turn around and tell them that their belief isn't of sufficient seriousness, cogency, cohesion, or otherwise in a democratic society? I say again, not an entirely difficult challenge for a claimant to surpass. If we then turn to the 5th and final criteria, and this, I will say, is the area where you must, I repeat, must read the Forstater decision. If for nothing other than it is topical, it is of interest, it is one of the, as it stands, one of the greatest dividing debates, I would suggest, in society, the gender critical debate. It is an area where Forstater covers that quite clearly, but it clearly covers the 5th and final element of the Granger test. Now, on its face, what is worthy of belief of respect in a democratic society and not incompatible with human dignity and not conflicting with the rights of others? Now, again, fairly stringent criteria on its face, but let's look at what the EAT said in Forstater. Paragraph 9. In our judgment, it is important that in applying Granger 5, tribunals bear in mind that it is only those beliefs that would be an affront to convention principles in a manner akin to that of pursuing totalitarianism or advocating Nazism or espousing violence and hatred in the gravest of forms. It goes on. But to my mind, that shows the standard which is being applied even at the 5th test. I rather suspect that there aren't many views, beliefs or otherwise, which would fall into the category of being akin to advocating Nazism. That is, again, I would suggest, and I'm giving you just my opinion, but that I would suggest is a fairly difficult category for any set of beliefs to fall into. Now, why am I saying all of this? And I said right at the beginning, I'm saying all of this because it got me thinking, as a relatively long-standing employment law practitioner, there may well be cases which come across your desk, whether you're an employee firm, whether you are a respondent firm. You may have internal disciplinary proceedings, for example, ongoing, and an employee says, I'm not doing that because I believe X. And it may just simply pass you by that that individual is doing anything other than setting out an opinion, but one which isn't protected by the Equality Act. I would ask us all to proceed with a bit of caution in respect of that. You'll see in paragraph 10 of my example, I think it is important to go by some examples. I'm going to ask you not to look at paragraph 10. I'm going to ask you to close your eyes for a second. Not really. But I am going to ask for a bit of audience participation, because everyone loves a bit of audience participation when you are the 5th speaker in on a Friday afternoon. Now, I'm going to give you 3 examples, and I want you to all give me a show of hands if your first opinion, as very intelligent, very respectable, as we all are, employment lawyers, whether your initial viewpoint would be that this was a protected belief, i.e. a protected philosophical belief. Now, Vegetarianism. Hands up if your view would be that that is likely to be a protected philosophical belief. Yeah, I'm with you. I think I would have said vegetarianism probably is. Well, case of Conisbee and Crossley Farms case, that was a first instance decision, found it wasn't in that case. That wasn't a protected philosophical belief because it was based simply on a lifestyle choice. Next one, ethical veganism. Yes or no? Yes. I would agree, I would say yes. Yeah, anyone not got the hand up for that one? No, everyone's now putting their hands up very furiously. Yeah, you're right. I think that's an obvious one. That, to my mind, is a protected philosophical belief. Each of these are fact-specific, but that one was held to be one. In fact, it was conceded by the respondent in the case of League Against Cruel Sports. The last one I'm going to choose out of my lists. A commitment to public service for the common good. Hands up if your view would be that that is a protected philosophical belief within the Equality Act giving you rights not to be discriminated against. Yeah, oh, we've got one at the back. Yeah, we're slowly coming up. Yeah, much more hesitant, I agree. I frankly probably would have kept my hand down, but I would probably be told I'm wrong by the judge in the case of Anderson and Chesterfield High School. That one was a case where a commitment to public service for the common good was found to be a protected philosophical belief. I'm going to end by just setting out a few words of wisdom, and because I'm very conscious I don't want to drag this on much longer for you all. If we look from paragraph 13 onwards, my words of wisdom are these. Think and think with caution. I hope I've made the point throughout that it really is important to give some thought to whether or not what is being put in front of you, it may be someone telling you they are evincing, doing something because of a philosophical belief, and ask yourself, right, what do we do? My advice to employers, for example, would be exercise caution, act as if that person is doing something because of a philosophical belief, and afford them the protections you would otherwise have afforded them if you knew them to have a philosophical belief. Much rather that than find yourself in the Employment Tribunal having it hashed out in front of a judge who then finds that actually you were wrong all along.